In today's webcast, we're going to talk about one of the uglier areas of litigation, and that is the will contest. I've handled a lot of litigation surrounding estate matters, and those can be the nastiest and the ugliest, and the ones that are the most emotionally draining for the parties. The first thing to do, if you want to try to avoid this, is make sure that your documents regarding the will and what you want to do with your property upon your passing, make sure those documents are professionally prepared and that your wishes are clearly set forth in these documents. That is the best way for you to avoid a will contest with your heirs after you die, because that's something you don't want to happen. In the event there is a will contest, again, these are very nasty proceedings, unfortunately. It's very emotional. It typically involves, it's right around the time that someone has just suffered a loss, oftentimes a parent. It can involve children versus children, relatives versus relatives, and it can be really a negative drain, and it can destroy families. And you want to try to avoid it. The first thing the court is going to look for is what's called testamentary capacity. The court wants to make sure that the decedent, the individual who wrote the will, the individual who decided where his property was going to go, wants to make sure that that individual had the appropriate capacity to decide where the money was going to go. The court's going to look to things such as, was there undue influence? In the case, was some relative coming in and improperly influencing the decedent? The court's going to look to a lot of issues in terms of the records of the individual. Did the individual have the proper capacity? Was the individual suffering from some type of mental impairment? The court is going to be very concerned if they see someone who's suffering from mental impairment, especially where there's a last-minute change to the will. The court's going to be, that's a little bit of a red flag for the court where there is this last-minute change. One thing to keep in mind when you're looking at a will contest is the decedent's capacity is presumed to be appropriate. It's presumed that the individual knew what they wanted to do with their money. And if you want to challenge a will, you're going to have to overcome that presumption of testamentary capacity, and that can be very, very difficult. So the first rule, again, is make sure that your will is in order, and if your will is not in order, there could be some difficulties with your heirs later on down the road, and you want to try to avoid that. Thank you.